Hello students, welcome to Guidance IAS. Myself Dinesh Ahirrao and I am working as an assistant professor of political science in one of the colleges of Delhi University. Well, the basic purpose of today's seminar is to familiarize you with the syllabus of Indian Polity and Constitution of UPSC. So in this particular session, I am going to discuss the syllabus as well as some of the previous year questions of UPSC Mains 2021 of GS Paper 2 of Indian Polity and Constitution. See, since this particular seminar is meant for the beginners, I would like to tell you certain important instructions about how you should begin your preparation, right? So, first thing you must do while preparing for any exam, right? Whether it is UPSC or any other exam for that matter, is to understand that exam in toto, right? You have to understand that exam very well. What are the requirements of that exam, right? Without understanding the examination, its pattern, so on and so forth, you can't begin your preparation, right? So the first thing you should begin with is to go through the syllabus of that exam, right? So as far as UPSC is concerned, without reading any single word, first thing you should do is to understand the scheme of examination, the structure of examination. So, and you can do that by you can understand the exam by understanding the syllabus. So first, go through the syllabus of both prelims and mains, right? Be it Indian polity, be it history, be it any other element of UPSC, right? Now, the second important aspect you should follow is, you should know what are the questions UPSC asks, right? Right. So, to that, along with understanding the syllabus, you should go through the previous year questions of both prelims and mains, right? Then only you'll understand what are important aspects upon which UPSC emphasizes upon. See, remember one thing, UPSC never repeats questions, but it do repeats themes, right? And there are certain themes which are very, very popular amongst, UPSC examiners, right? So in order to understand what are the issues, what are the concepts which are very, very important for UPSC as an exam, you need to go through previous year question papers, right? So these are the two things I have observed that many of the students they don't do. The students more often than not, what they do is they straight away go to the market, they will buy the books and they will start reading the books. Do not do this mistake, right? So, before reading even a single word of, say, Indian polity or, say, Lakshmikant or any other book for that matter, you should understand the philosophy of that exam. You should understand the requirement of that exam, and this you can do by understanding the syllabus, and second, by going through the previous year question papers. And that is what precisely we are going to do today. We are going to understand the syllabus of Indian polity and constitution, and we are also going to go through some of the previous year question papers, particularly UPSC GS Mains 2021, right? Now, the purpose is, along with familiarizing you with the scheme or a structure of examination, I would like to tell you certain tips about answer writing. Because answer writing is something which is very, very important, and which is more often than not is ignored by particularly beginners or those who give first attempt. Why? Because when students give their first attempt, everything is new for them, right? It will be new for you guys as well, right? So what you do, you only go on reading and reading and reading, because you feel that answer writing is something you will do after completing the syllabus, after having the hold over the content, and then you will start with the answer writing. And now this is the mistake which most of the candidates do. Yes, having hold over the content is very, very important, but along with this, you also should know how to put that content in a specific period of time, within a specific words, right? The knowledge which cannot be expressed in a limited space and within a limited period, that knowledge remains, it has no it has no use or meaning as far as UPSC is concerned. Because if you look at the structure of UPSC, the maximum marks are allotted to mains examination, right? It is the mains which is the heart and soul of UPSC. Yes, right? So you can clear UPSC, you can get good post only if you get good score in mains. And you can get good score in mains only if you have mastered the answer writing skills. So that is why answer writing is very, very important. So while I'll discuss the UPSC mains questions of Indian polity of 2021, my primary focus will be to tell you certain tips of answer writing, certain mistakes to be avoided, not to just give you the content, because content you'll get anywhere, right? Fine. So this is the basic structure of today's lecture. So let's begin. So let us discuss first the syllabus of mains of GS paper 2. Now GS paper 2 consists of three elements. I mean, in simple terms, right? So first is Indian polity and constitution, then international relations, and third is governance and social justice. These are the three essential elements of GS paper 2 mains, right? So if you look at the syllabus begins with this bit, right? Indian constitution, historical underpinnings, evolution, features, amendments, significant provisions, and basic structure. So basically, the very first part of the syllabus, it consists of heart and soul of Indian polity or Indian constitution, because it deals with historical underpinnings, as in how the Indian constitution was framed, right? What was the composition of Constituent Assembly and its criticisms, how many members, so on and so forth. Then evolution, how the Constitution of India evolved over a period of time, right from the British colonial rule till today. It's, Constitution is an evolutionary document. It evolves on the basis of needs and circumstances of a contemporary society. So Constitution is never a static document, right? Okay. Then this particular aspect is very, very important. This talks about salient features of Indian Constitution. There are various salient features which we are going to discuss in detail in our classroom program. Then amendments. The key amendments have defined the Constitution, or sometimes some of the amendments basically have changed the course of the Constitution itself. So we will have to study key constitutional amendments. We will also discuss the amendment procedure as well, as provided under Article 368, different types of amendments, so on and so forth, significant provisions. And the most important element of this particular part is basic structure doctrine. This is very, very important. If you analyze the previous year questions of UPSC mains GS paper 2, UPSC has asked at least two times the question on basic structure since 2013, when the new scheme or a new syllabus was framed. So basic structure doctrine is extremely important a topic of your polity. It is, and basic structure doctrine is something which is linked with so many aspects, right? So this basic structure doctrine we are going to study in a very systematic manner. One thing I would like to tell you is that, for UPSC, conceptual clarity is of a paramount importance. You cannot clear UPSC by mugging up things. You have to have some conceptual clarity, and basic structure doctrine is something which will test your concepts or your clarity over concepts, right? And this basic structure doctrine, you will know that it was given by Supreme Court of India in Kesavananda Bharati case. So we are going to study that as well, right? So this is the first part, which basically consists of a heart and soul of the syllabus, right? Historical underpinnings, evolution, amendment procedures, salient features, basic structure. Then the second, second topic deals with the federalism or a federal structure as contained in the Indian Constitution and its functioning, right? So it deals with functions and responsibilities of union and state, right? Indian Constitution is federal constitution, right? Some call it as quasi-federal, some call it as, cooperative. Indian Constitution provides for cooperative federalism. There are a lot of debates which we are going to discuss in our classroom program, right? And the important along with the first topic, this second topic is also very important as far as mains is concerned, because there are so many questions with respect to federal structure, right? So the theme is going to be the same: issues and challenges regarding the federal structure, but the questions will be different. So that is why I told you in the beginning that you have to go through previous year questions of both prelims and mains in order to understand certain important themes upon which UPSC repeatedly emphasizes upon, right? So federalism, federal structure, then local bodies, Panchayati Raj institutions, urban local bodies, 73rd and 74th Constitutional Amendment Acts, basic structure doctrine. These are some of the important themes, and that is why UPSC has mentioned these two aspects in the initial part of the syllabus itself, right? I hope you're understanding. And those who are watching online, you can ask your questions. You can stop me anyway, anytime, whenever you feel like that, right? And I'll answer your questions, right? Then the third is also very important: separation of powers between various organs, right? So, government has three organs, right? Legislature, executive, and judiciary. And the Constitution of India provides for parliamentary form of government, right? And the parliamentary form of government is based on some kind of separation of powers. And along with the separation of powers, there is checks and balances as well, right? See, there are two forms of government. One is presidential form of government, and another is parliamentary form of government. Now, the presidential form of government is based on strict separation of powers between three organs, right? Wherein the three organs are more or less mutually exclusive. No one organ will interfere into the powers and functions or sphere of influence of the other two organs, right? This is what separation of power is all about. But when it comes to parliamentary form of government, in the parliamentary form of government, there exists a separation of power between three branches of governments, namely legislature, executive, and judiciary. But this separation of power is not that strict as it existed presidential form of government. So Indian Constitution, along with separation of power, also ensures it, or it also provides for the principle of checks and balances, right? Principle of checks and balances. Now UPSC, now this is a concept, right? Separation of power and checks and balance, and UPSC has asked question on this as well, right? Then the next bit is dispute redressal mechanism, right? In a democracy, citizens might have a lot of grievances, a lot of dispute might arise between different groups, different citizens, so on and so forth, between state and central government, between state itself, right? So this is about the dispute redressal mechanism, not between the citizens, but between the central government and the state government, or between the states themselves, right? So this is also related to the federalism, right? Then the next is very, very important, and this particular topic is often ignored by the aspirants. That is comparison of Indian constitutional scheme with that of other countries. Now, UPSC, UPSC, believe me, UPSC knows, the people who are at the helm of the decision making in UPSC, they know your strengths and weaknesses. Right. So this particular topic is often ignored by the students. Why? Because they feel that there is not enough material available with respect to this particular topic. And believe me, that is why UPSC this year in mains 2021 did ask one question, which we are going to discuss in the later part of the question about this particular topic: comparison of Indian constitution with the constitution of other countries, mainly USA and UK, right? Even last year, I guess, there was a question about a comparison between the judiciary of India and judiciary of UK, right? This year they asked question about right to equality as it exists in Constitution of USA and Constitution of India, right? So two questions have been asked. So you have to prepare this particular topic very well, and we at Guidance IAS, we are going to give you a very detailed and a very systematic course material or subject material, including on this topic, because most of the students don't have solid content over this, right? Then the next, let's move forward, and the next, the next two topics basically are related to or three organs of the government, right? The executive, right? The legislature, the executive, and judiciary. So You have to study parliament and the state legislature, the structure, functioning, powers, conduct of business, privileges, and issues arising out of this, right? So this particular topic is related to parliament as a legislative body or state legislature, right, including the state legislature, so legislative organ of India, right? And even this year they ask question regarding Indian parliament as well as state legislatures. They ask question on legislative councils, right? They ask question on department related standing committees, and also effectiveness of parliament in ensuring the accountability of the executive. So again, this particular topic becomes very, very important because parliament is embodiment of the will of the people. You know, parliament is highest deliberative and representative and highest lawmaking body in India. So you cannot understand Indian polity without understanding the parliament as well as the state legislature, its powers, functions, and different institutions with which parliament functions, including parliamentary committees. Right? Clear? Fine. Then the next is structure, organization, and functioning of the executive and the judiciary, the other two organs, right? So you have to study parliament, you have to study executive as in union executive as well as the state executive, prime minister, president, so on and so forth. Judiciary, again, this is very important topic for UPSC, and this is the theme which UPSC often repeats. Various questions they have appeared in UPSC mains as well as in prelims regarding judiciary, right? So judiciary is also very, very important. So the point I am trying to tell you is that all the three organs of government are very, very important from UPSC perspective, right? And you have to study, and we will be studying all these three organs in detail. Then the next particular topic is about pressure groups and formal and informal associations and their role in polity, right? Now, this is also a theme which UPSC often repeats. A role of pressure groups, how far they are successful in influencing. Last to last year they asked question about farmers pressure groups. This year they asked question about business pressure groups. Right. So the theme remains the same. Pressure group. The theme remains the same. The questions, the UPSC asks questions through different. It just frames different questions around the same theme, right? So people say that, oh, UPSC never repeats the question. Yes, that's agreed, accepted, but it does, it has some favorite themes. And I hope that by now you know certain important themes, right? Federalism, basic structure doctrine, parliament, judiciary, executive, so on and so forth. Then next is again very important theme, salient features of Representation of People's Act 1950 as well as 1951, particularly 1951. Again, this is very important aspect because the Representation of People Act basically deals with the actual conduct of elections and various rules and various regulations, right, about conduct of election. So that is why this particular topic becomes very, very important. So this deals with disqualification of member of additional manner of disqualification of member of parliament or member of state legislative assemblies, so on and so forth. Then it also deals with a certain aspect of actual conduct of elections, and there are various recommendations given by Election Commission of India, various committees and commissions set up from time to time regarding electoral reforms. So there are various electoral reforms can be done only through amending. I mean, most of the electoral reforms can only be done through amending Representation of People's Act, right? Not all, but at least some of them, right? So that is why this particular topic we have to study along with electoral reforms. Again, that is a very important theme. The next is appointment to various constitutional posts, powers, functions, responsibilities of various constitutional bodies. See, Constitution of India establishes various constitutional bodies or constitutional institutions. Now, it is very important to understand what are constitutional bodies or what are constitutional institutions. See, institutions can be established through various ways. Okay? One way of establishing institution is through constitution itself. right? Meaning to say, constitution itself might provide for establishment of particular institution, right? So those institutions which are established under the provisions of the constitution itself, they are called as constitutional bodies. I repeat, constitutional bodies or constitutional institutions are those institutions which are established directly under the provisions of the constitution, right? Now, for example, UPSC. UPSC is a constitutional body. Why? Because UPSC has been established directly under the provisions of the Indian Constitution. It is established under Article 315 of Indian Constitution. And that is why UPSC becomes constitutional body. Then Comptroller and Auditor General of India. It is also a constitutional body. Election Commission of India is also a constitutional body established under Article 324 of Indian Constitution. Got it? So one way of establishing various institutions and bodies is directly through the Constitution. See, democracy is known by its institutions. If the institutions are strong, democracy is going to be strong. If the institutions are weak, or if the institutions they fail to perform, democracy is going to be weak, right? And that is why UPSC has incorporated this particular topic. Now you have to study about various constitutional bodies: Comptroller Auditor General of India, Election Commission of India, then along with that, you also have to study various other constitutional bodies like National Commission on Scheduled Caste, National Commission on Scheduled Tribes, right? National Commission on Backward Classes, right? So these are the various constitutional bodies. Now, the another way of establishing any institution or body is to establish it through a law of the legislature. Now, those institutions or bodies which have been established under the law of the legislature, which can be parliament or that can be state legislature as well. Such bodies are called as statutory bodies, right? So we have constitutional bodies, then we have statutory bodies. What is the difference between constitutional bodies and statutory bodies? The constitutional bodies or institutions are those which are established under the provisions of constitution itself, whereas the statutory bodies are those bodies which are established under the provisions of particular law of the legislature. For example, National Commission on Women or National Human Rights Commission, National Commission for Protection of Rights of Children. All these are bodies, all these are statutory bodies. Why? Because they have been established under the law of the parliament, which is the central legislature. For example, National Human Rights Commission is a statutory body established under Protection of Human Rights Act 1993, which is an act passed by the parliament. Got it? The difference between the statutory body and constitutional bodies? Fine. Now, the third way is to establish a body through resolution of the executive. Right? Executive meaning government, council of ministers headed by prime minister, central government, or council of ministers headed by chief minister, state government, right? So there are certain bodies which can be established merely or simply through the resolution of executive. Executive can be union executive or state executive. For example, Niti Aayog, right? Niti Aayog, is it a constitutional body? No. Constitution of India nowhere provides for Niti Aayog. Is it a statutory body? No. Is there any Niti Aayog Act? No. So how Niti Aayog has been established? Niti Aayog has been established through the resolution of Union Cabinet, which is an executive, right? It has been Union Cabinet through resolution in 2014 decided to establish Niti Aayog, and Niti Aayog therefore was established on 1st of January 2015. So that is why Niti Aayog is a, is neither a constitutional nor a statutory body. It is extra constitutional and non-statutory body. It is non-constitutional or extra constitutional or non-statutory body. It is neither constitutional body nor statutory body, right? Then CBI. CBI is also non-constitutional and non-statutory body. Most of the students, they confuse. They feel that CBI is a statutory body. See, CBI is an executive. It has been established in 1963 through the resolution of Union Home Ministry. That is executive. So that is why it is non-statutory body, and there is no question of it being a constitutional body, because constitution nowhere mentions about CBI, nowhere talks about CBI, right? But it derives its power from a particular law, that is Delhi Special Police Establishment Act of 1946. Yes, it derives its power. Sorry, the CBI derives its power from a particular law, but it has not been established under that law. It has been established through the resolution of Union Home Ministry. So that is why CBI is non-statutory body, right? Got it? So you have to study about constitutional bodies, you have to study about statutory bodies, and you have to study about various non-statutory bodies as well, right? And this particular bit of the syllabus talks about constitutional bodies. Then again, see the statutory bodies. I told you what are the statutory bodies. Okay, regulatory bodies. There are certain regulatory bodies in India as well. TRI or RBI is also a regulatory body, so on and so on. There are quasi-judicial bodies. NHRC is a statutory body and it is quasi-judicial body as well. Quasi-judicial bodies are those bodies which have some powers enjoyed by the judiciary, right? Quasi-judicial bodies are not part of judiciary, right? They're not part of judiciary, but they do exercise certain powers which are enjoyed by the judiciary, right? So they are quasi judicial body, meaning bodies similar to judiciary but not part of judiciary, right? So here we are going to study those various bodies, quasi judicial bodies. Then this is about the syllabus of GS paper 2 for mains, right? So if you look at the syllabus is very, it is crystal clear. Those students who believe that UPSC syllabus is very vague, it is not precise, I don't agree with this particular view. See, UPSC syllabus is really clear, but you have to understand, you have to know the syllabus first. Many of the students don't go through the syllabus. And again, I'd like to emphasize that going through the syllabus should not be a one time process. No, going through the previous year question papers should not be a one time process. It should be an integral part of your preparation, previous year questions and syllabus. So whatever you study, whatever article you study in newspaper, whichever magazine you read, whichever textbook you read, you should know from which topic of the syllabus this particular chapter is all about, this particular article is all about. Is there any topic of the syllabus which I can identify with that particular article or with that particular chapter of that book, right? So every day, you take the printout of see, there is one important success mantra for UPSC, and that is, you have to remember the syllabus by heart. The entire syllabus of UPSC should be on your fingertips, right? The moment any question is asked in UPSC, you should directly be able to know or decipher from which particular topic of the syllabus UPSC has asked that question. And once you decipher that particular topic of the syllabus, you believe me, your answer writing is going to be very easy. Now, more often than not, students do not understand the question itself. Why? Because they don't know the syllabus. So going through the syllabus should not be a one-time process. As in, you're a beginner, you will go through the syllabus, and once you have gone through the syllabus, you'll forget. No, it should be an integral part. It should be a continuous process unless and until you clear the exam, right? Second, going through the previous year questions should also be a continuous process. It cannot be one time process, because what happens is that whatever we study in the beginning we tend to forget. Human brain has a limited capacity to accumulate the information, or to remember that information. So you have to continuously repeat the process every time and again, right? So remember this is very very important, because most of those candidates, they do go through the syllabus, they do go through the previous year question papers, but only once or twice, only at the beginning phase of their career, of their preparation, and not after that. No, never repeat, never do this mistake, right? Got it? Fine. Now let us go through the syllabus of prelims quickly. Yes, it is about Indian polity and governance, constitution, political system as in parliamentary form of government. What are the salient features of parliamentary form of government? Federalism, Panchayati Raj institutions, 73rd Constitutional Amendment Act, urban local bodies, 74th Constitutional Amendment Act, public policy, public policy making, rights issues, various issues regarding rights. Hmm? So there is some overlap of UPSC prelims and mains syllabus of polity, right? But the syllabus of mains is more precise and more comprehensive. Hmm? Then the next is political systems, democratic and non-democratic systems, parliamentary and presidential systems, a form of government, unitary and federal, direct and representative, direct democracy, indirect democracy, republic and monarchy. Acha, let me explain one concept: republic and monarchy. No, see why I'm explaining some concepts is to generate interest of you guys in the fascinating subject of Indian polity and constitution, right? So what is the difference between republic and monarchy, right? And another thing I would like to emphasize here is that one of the important qualities of bureaucrat is bureaucrat should never beat around the bushes. Bureaucrats should be very precise in answering the questions. Bureaucrats should have conceptual clarity. If the question is about what is the difference between republic and monarchy, bureaucrats as a future bureaucrats, you can't write an essay on this. You have to hit the bull's eyes, right? So what is republic? Republic is a form of government in which head of the state is directly or indirectly elected by the people. What is republic? One single line. Republic is a form of government in which head of the state, which is president, right? Huh? More often than not, head of the state is either directly or indirectly elected by the people. Now, why India is republic? Is India a republic? Definitely it is a republic. Why? Preamble of Indian Constitution declares India as a republic, democratic republic. Because in India, head of the state, that is president, is indirectly elected by the people, right? Through electoral college, right? So that is why India is republic. What is monarchy? Monarchy is a form of government in which head of the state, right? Head of the state is hereditary monarch, who can be a king or can be a queen. So in two sentences, you can differentiate republic from monarchy. And this is called as hitting the bull's eye. There are other differences as well, but this is the fundamental difference, right? In republic, head of the state is directly or indirectly elected by the people. USA is also republic. Why? Because in USA, head of the state, that is president of USA, is also indirectly elected by the people. President of USA is it is never directly elected by the people. He or she never directly elected by the people. He is also indirectly elected by the people, like Indian president, right? Whereas Japan or say UK, these are all monarchies. Why? Because in Japan and UK, head of the state is hereditary monarch. In Japan, we have Emperor of Japan. Then in UK, we have Queen Elizabeth II as the monarch. And the Queen Elizabeth, she never became the queen by contesting any elections. She has occupied this position through hereditary succession. Okay? This is the first difference. Second difference between republic and monarchy is that in republic there is absence of privileged class. In Republic, every person or every citizen is treated equally, and there are no privileges whatsoever, right? There are some exceptions as well, but yes, Republic, there is absence of. In Republic, there are, apart from certain exceptions, there are no privileges in Republic. Whereas in monarchy, monarchy is characterized by presence of privileged class. For example, only person belonging to a particular family can become monarch in UK. Whereas in India, anybody who fulfills the constitutional requirements can contest election to the president, and he can become a president of India, right? Fine. So there is absence of privileged class in Republic, whereas in monarchy there are certain privileges which are exclusively available to certain class, or in this case, the royal families, right? So this is some simple difference. Then we also have to study about constitutionalism, and this is very famous theme which UPC often repeats: constitutionalism. uh, Let me take this question. So, which reference book is good for mains and PT as well? All right, this question is a very. It is more. It is very often asked question. See, for prelims, I'll say Lakshmikant is a decent enough book, right? But for mains, reading Lakshmikant is not enough. Along with Lakshmikant, you have to follow class notes given by us in classroom, right? So class notes, I'll be teaching you Indian polity and constitution. The notes which I'll be giving you will be a combination of various aspects taken from various good books, like Subhash Kashyap, Didi Basu, and as well as certain important articles which often comes in the newspapers, and as well as my own analysis, my own understanding, and my own experience as an assistant professor of political science from last 7 years, right? So you cannot for prelims, Lakshmikant is very good book, but for mains, Lakshmikant has more or less, it has more factual information, right? But as far as analysis is concerned, you have to go beyond Lakshmikant, right? uh, Got it? I hope your question is answered. Manish Sharma, yes, Lakshmikant is not good enough for mains. That is what precisely I am telling, right? So you, along with Lakshmikant, you have to follow class notes. Because, I will not tell you to go for Subhash Kashyap or say Didi Basu or any XYZ scholarly book. See, understand that, in UPSC, you're not, you're supposed to be you're preparing for an government exam. You're not preparing for any academic exam like PhD or MPhil, and there is no MPhil now, but PhD or say masters, post graduation, right? So you are not supposed to do PhD or in a particular topic or a particular subject. No. And second thing, you're supposed to limit your sources. Now again, this is the mistake which candidates often do commit, that rather than limiting the sources, what students do, they'll go into the market, they'll buy Lakshmikant. Then the next day they'll go to the market, that some friend will tell him, oh, Lakshmikant is not enough, you have to buy Subhash Kashyap as well. Then they'll buy Subhash Kashyap. Then someone will say, oh, don't read the Lakshmikant and Subhash Kashyap is not enough, Didi Basu is also important. Again, that particular person will buy Didi Basu. So what happens is that you do not have you have limited time for your preparation. So for one particular subject, you can't go and read three textbooks. You cannot. There should always be a cost benefit analysis. Always do cost benefit analysis, right? So follow, rather than reading from multiple sources, limit your sources, stick to only one source or at most two sources, and revise these sources again and again. Have trust in those sources, right? Whenever another person tells you, say, oh fine, I don't agree with you, if you want to read that book, you read, but I'll follow this. This is very important, because you are not a PhD scholar. You're not going to appear for PhD entrance examination, right? For example, I am a research scholar, I am an assistant professor, so I might I have enough time to read those books, right? But you as an aspirant, you have to study about Indian history, science and technology, environment, ethics. Oh, I mean, there's so much things to read. So limit your sources and have trust in your teachers, and have trust in whatever sources you read. So at the outset itself, you prepare a list of what are the important books which you are going to read from, and these books are often known, right? For example, for history, students read Spectrum. That is a very good book. See, one another important thing about UPSC is that, read less and think more. This is very, very important. What candidates do is, particularly the beginners, they go on, and even I commit this mistake. I committed this mistake when I was aspirant 10 years back. I used to read everything. I used to like reading everything. I thought, oh, this is also important. I used to think this is also everything is important. And that is why I could not get enough time to complete the entire syllabus. And that is why in the final merit list I could not get selected, right? So based on my own experience, both as a candidate, as a civil services aspirant, and as well as a professor, as an assistant professor or a teacher, I'll tell you that, please limit your sources. Limit your sources, believe in your sources, believe in your teachers, right? And focus more on thinking, analyzing, rather than only reading. 50% reading, in fact 40% reading, 60% thinking. Very important. The main questions, they test your thinking ability, they test your critical mindset, they test your questioning attitude, right? So this is very important. Fine. All right. So next topic is okay. Constitutionalism is again often repeated theme in UPSC, particularly in prelims. So constitutionalism. What is constitutionalism? In simple terms, constitutionalism means limited form of government. A government which is guided by the Constitution. And one of the important functions of the Constitution is to put certain limitations on the powers of the government to prevent that government from using its powers in an arbitrary and whimsical and unjust and absolute manner. That is what constitutionalism is. So constitutionalism is very, very important principle, right? So rule of law is also a part of constitutionalism because it ensures limited form of government. You cannot give unlimited powers on to the government, because then that government is bound to become dictatorial or totalitarian. Lord Acton, he once said that power corrupts and absolute power corrupts absolutely. So that is why powers should always be limited. So constitutionalism means a form of government which is limited. Constitutional government is a government whose powers are limited by the constitution itself, not by any law of the parliament or the state legislature, but by the constitution itself. All right. Then historical underpinnings. This particular topic is there in the mains as well. Evolution and making of the constitution, how constitution of India was made, right? Cabinet mission plan, constituent assembly, indirect elections, so on and so forth. Features and significant provisions. The preamble. Again, preamble is very, very important topic, because preambles embodies or signifies the basic philosophy of the constitution. Hmm? So the next is union territory, citizenship, fundamental rights, directive principles of state policy, fundamental duties. So union and its territory is part 1, citizenship part 2, fundamental rights part 3, directive principle of state policy part 4 of the Indian Constitution, part 4A, amendment of the Constitution, Article 368, basic structure doctrine, which is there in the mains as well, emergency provisions, right? Indian Constitution provides for three types of emergencies: national emergency under Article 352, state emergency or constitutional emergency, or which is popularly known as President's Rule under Article 356, and a financial emergency under Article 360. So in detail, we'll have to study this. Constitutional bodies, yes, State Public Service Commission, Finance Commission, Article 280, right? UPSC, Article 315, Election Commission, 324, CAG, 148, Attorney General of India, Advocate General of India, right? 76, so on and so forth. So these are all constitutional bodies till here. Till here. These are all constitutional bodies. Okay? Because they are established under Provisions of the Constitution itself, directly under the provisions of the Constitution. Constitution itself makes provisions for these bodies, all these bodies. Then non-constitutional bodies, right? So Niti Aayog is non-statutory body. Why? Because it has been established through the resolution of Union Cabinet. NHRC is a statutory body. Then Governing Council, State Human Rights Commission, Central Information Commission, CBC, CBI, Lokpal, Lokayukt. These are very important topics, particularly for prelims, because UPSC might ask question regarding the composition, structure and composition, powers and functions of constitutional bodies as well as non-constitutional and statutory bodies. President. So this is about executive, president, vice president, prime minister, union executive, right? Then Central Council of Ministers, cabinet committees, cabinet secretary, chief secretary. So this is about the executive, union executive. Then Parliament, Council of States. This is about legislature, union legislature. Disqualification, vacation of seats, presiding officers of Parliament, Speaker, Deputy Speaker of Lok Sabha, Chairman, Deputy Chairman of Rajya Sabha. Then working and functioning of the Parliament, parliamentary committees, and making of budget, law making. These are very important topics. How laws are made, how budget is passed, what are parliamentary committees, why do we need parliamentary committees, what are the different type of parliamentary committees, what are ad hoc committees, what are statutory committees, so on and so forth, right? Sir, how to do revision in short time? Tell me some shortcut strategies. Now, this is very interesting question. This is called as a question from millennial generation 21st century generation. See, there are no shortcuts to success. There are no shortcuts. No, I'm sorry. There is no magic wand. I can't give you magic wand that you follow this shortcut, read for 2 months, and you can become an IAS officer. If I do that, it means I am lying. See, do not be in a hurry to clear this exam. This is a beautifully drafted examination, and please enjoy the process. Enjoy the process. Don't be in a hurry. I hope, I know that there is rat race going on. In old Rajendra Nagar, we are all standing in old Rajendra Nagar. There is rat race going on. Everybody there is a cutthroat competition, tooth and nail competition. People are competing with each other, and then in all this rat race, you tend to forget why we are preparing for UPSC. What is the purpose? Why we should know Indian Constitution? Why should we study polity? This is very important. So please, whoever has asked this question, there are no shortcuts. There are no shortcuts. Believe me. First, you follow a proper procedure, proper process. Yes, make a plan, proper plan, follow that plan, enjoy the process. Have this confidence that, or have this belief that by deciding to prepare for UPSC, you yourself have decided to take a challenge, and you're getting to know so many things. You're getting to know about Indian history, about art and culture, about Indian polity, about Indian economy, which otherwise, if you would have not prepared for UPSC, you would have not known. Like the commoners, like the IITians. Why IITians and IIM graduates, why they go for UPSC? Because they know that what is very important is satisfaction, and you will get satisfaction only when you will enjoy the process. So do not go for shortcuts. First, follow the particular process. See, in cricket, there is one important rule, that is follow the basics. Virat Kohli is one of the finest batsmen in the world. Why? Because he has followed the basics. There are certain basics which you have to follow. So even for UPSC, or for any exam for that matter, you have to follow certain basic rules. It is not, clearing UPSC is not rocket science, believe me. There is so much of awe and there is so much of pressure which has been created by the society that you tend to feel that, oh, this is extremely difficult, and it is very it is something which is extraordinary, so on and so forth. Yes, it is a difficult examination, but people do clear this examination as well. People are clearing UPSC in first attempt itself, and believe me, they have not cleared by following the shortcuts. No, never. Right? So please follow the standard. There are certain standard operating procedures, SOPs, and whatever I am discussing, these are all SOPs. Go through the syllabus, go through the previous year question papers, read NCRTs, build your foundation, limit your sources, revise again and again, practice answer writing. These are all standard operating process. These are all standard operating procedures, and please follow that. Okay. Yes, for revision you can follow certain tactics, short tactics, like you can prepare 2 to 3 pages notes on a particular topic, 200 to 300 word notes on a particular topic, then you can revise. So in that sense you can have shortcuts, but as far as conceptual understanding is concerned, you cannot go for we cannot go for shortcut strategies. If you go for shortcut, you will lose the essence of that particular topic. And if you do not know the essence or the basic aspect of the particular topic, you will not be able to write good quality answers. I hope I have answered your question. So the point to be noted here is that do not be in a hurry to clear this exam. Believe me, the real game will begin when you will enter into the system. So prepare yourself, abreast yourself for that particular challenge. Clearing UPSC is only half the job done. The main, in fact, not even half, the main job, the main challenge will be once you enter into the system, because the system, believe me, is fraught with so many challenges. So prepare yourself for that. Focus on your personality development. Focus on developing what are called as OLQs, officers like qualities, right? Because I have seen so many candidates who have cleared UPSC, but once you talk with them, once you speak with them, that it does not generate respect, or it does not generate awe around that particular person. Do you want people to tell you that this person has become IAS? How he has become an IAS? He doesn't behave like an IAS. This is the biggest disrespect you'll feel once you enter into the system. So focus on your personality development, and this will happen only when you will enjoy the process, and this will happen only when you will follow a long term approach for your preparation, because clearing an UPSC is only one aspect. Going into the system, sustaining there, and doing good job is a real challenge. I hope I have answered your question. Then governor, chief ministers, this is about state executive, right? Then state legislature, Indian federalism, center-state relation. Oh, this is very, very important. Center-state relations. In this, we are going to study about interstate councils, about recommendations of various commissions like Sarkaria Commission, Punchi Commission, so on and so forth. Again, Panchayati Raj institutions, urban local bodies. Most of these themes, they are often repeated again and again. Now, I hope till now you're getting to know the themes: Supreme Court, High Court, Judiciary, part of Judiciary. Then subordinate courts, district courts, Gram Nyayalayas. Yes, there are questions particularly in prelims about Gram Nyayalayas, whether there are statutory bodies, what are their powers, composition, ADRs, right? Alternative dispute resolution mechanism. Very important topic. Very, very important topic, because the Indian judiciary is burdened. It is overloaded, right? So that is why we have alternative dispute resolution mechanism, because Indian judiciary is already overloaded. There are more than 2.3 crore cases pending in various courts in India. On an average, it takes 3 years to solve a particular case in India, right? So the judicial process in India is extremely expensive. It is painstakingly slow, and it is extremely expensive. And that is why we have alternative dispute resolutions, which will be cheap, which will be cost effective, and which will be speedy, right? So that is why ADR, government, from last few years, government as well as judiciary is emphasizing every now and again on ADRs, right? National Legal Services Authority to provide free legal aid. and justice to poor people, elections and political parties, representation of People's Act 1950-51. I have already told you about this. Election process, Delimitation Act, anti-defection law. Again, this is very, very important theme, anti-defection law. 10th schedule. 10th schedule of Indian Constitution. 10th schedule. Sorry for my handwriting, right? 52nd Constitutional Amendment Act 1985 provide added 10 schedule in the Indian Constitution. So anti-defection law is one of the most progressive laws, as well as one of the most controversial laws passed by the Parliament. Right. So there are various aspects regarding anti-defection laws. There are so many loopholes in anti-defection law. There are various counter arguments that anti-defection law leads to party bossism. It restricts freedom of speech and expression, so on and so forth. Then the cases of defection, disqualification of member of parliament on the basis of defection are decided by presiding officers, speaker in Lok Sabha and chairman in Rajya Sabha. And these presiding officers, they play biased role in deciding the cases. So there are so many recommendations. For example, even Supreme Court of India said that the cases of disqualification on the basis of defection, on the grounds of defection, should be decided by independent permanent tribunal. They should not be decided by the presiding officers, because they are biased, they are partisan, right? Okay? So that is why anti-defection law becomes very, very important from UPSC, from the point of view of UPSC. Defection means a person who has contested election on a particular on a ticket of a particular political party, and after getting elected, that particular person changes the political party and joins another political party, right? Or he gives up the membership of that particular political party on whose ticket he contested the elections. So defection is immoral, unethical, unprincipled act, because you first contested on a ticket of a particular political party. People might have voted for you because of you belonging to that particular political party, and once you have got elected, you have changed your political party, or you have given up the membership of that party, which is unethical. So the purpose is good. The purpose of anti-defection law is good, but unfortunately there are so many loopholes and there are so many controversies. So that is why UPSC asks various questions. Do you think that anti-defection law has failed? What are the suggestions, remedial measures? And we are going to discuss this topic in detail in our classroom program. Then the other constitutional dimensions, rights and liabilities of the government, provisions related to languages, working of the constitution, National Commission to review the working of Indian Constitution. This is also called as Venkatachalaya Commission. It gave 2002 to 2002. It gave a lot of recommendations, right? Cooperative societies, tribunal is very, very important topic. The other topics are relatively less important, but the tribunals are very, very important, right? Tribunals are quasi-judicial bodies. Again, they are set up to provide speedy and inexpensive justice to particular section of society, right? So tribunal is very, very important topic, and UPSC has asked question regarding the tribunals, reforms of tribunals, so on and so forth. Now let us briefly analyze the trend, right? I'm not a big fan of trend analysis, by the way, okay, because UPSC, every year, every now and then, it changes the trend. But more or less, you can get a fairly understanding about how many questions of Indian polity and constitution UPSC asked in GS paper 2. Sorry. So if you look at from 2013 to 2021, on an average, we'll go according to the average, 10 to 12 questions. How many questions? 10 to 12 questions are asked from 10 to 12 out of 20, right? From Indian polity and constitution. So that is why so GS paper 2, in GS paper 2, I told you there are 3 sections: Indian polity and constitution, international relations, governance, and social justice. Out of these 3 elements, the most important element is Indian polity and constitution, because every year 10 to 12, sometimes UPSC has asked 14 questions from Indian polity and constitution. So that is very, very important. That is why you have to prepare it very well. So as far as this is concerned, trend analysis is very important, very good. We should do, but you can't. There is no fixed pattern you can see uh, in 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 uh, in uh, in mains, but average, on an average, you can say 10 to 12 or even 13 on Indian polity, and in JS paper 2, Indian polity and constitution is very important. Now, one important thing which I like to tell you is that, see, Indian polity and constitution is very easy to understand, right? And there are so many good sources available, Lakshmikant being one source, right? Now, since Indian polity and constitution is easy to understand as compared to other subjects, other topics like say science and technology, or say economy, or say geography, which are technical in nature, Indian polity and constitution, presumably, or candidates feel that it's very easy to understand, and that is why most of the candidates take GS paper 2 for granted, Indian polity and constitution for granted, because you feel that it is very easy. But once in mains, the questions appear. If you look at the performance of even the successful candidates in UPSC in GS paper 2, the performance is not extraordinary. You might have seen in GS paper 3, the successful candidate have got 120 or 125 marks. In GS paper 2, very rarely candidates cross 110 mark. Why? Because candidates take Indian polity and constitution for granted. They feel that it is easy, and since the moment you feel a particular thing is easy, you do not give adequate importance. You do not give adequate attention to that particular subject. So do not ever commit this mistake. Indian polity and constitution is easy to understand, accepted, but it is very difficult to analyze. It is very difficult to write answers. Once you start writing answers, you will run out of content, huh? Because you don't prepare it thoroughly. Okay? So please do not take Indian polity and constitution for granted, even though it is very easy to understand, presumably. But believe me, it is also a technical subject. There are so many important issues involved in the constitution. Its constitution is one of the complex documents, right? It is called as lawyer's paradise. Ivor Jennings called constitution as a lawyer's paradise. It's difficult. It was written by lawyers, right? So do not take it for granted. Give due respect to GS paper 2, Indian polity and constitution. That is what I am trying to convey. Then this analysis, you'll get it everywhere. Oh yes. Now what about prelims? Again, for prelims, GS, for prelims also, Indian polity and constitution is very important. On an average, you can see 15 to 20 questions, in 2013, 18 questions, 2017, 22 questions, 2021, 18 questions. 18 question is a huge, out of 100, 18, 20, 18%. It's a huge, okay? So on an average, 15 to 18 questions, they come from Indian polity and constitution, from right, this particular part. Now, from last 2 to 3 years, what UPSC is doing, UPSC is asking questions not on the basis of facts, but on the basis of conceptual understanding. Let me explain. Let me give you some of the examples, right? And you will not get the answers in Lakshmikant, right? For example, what is the most appropriate definition of liberty? This was the question asked by UPSC in prelims. What is the most appropriate definition of liberty? Now, this is a conceptual question. This question will test your understanding of the concept. Now, you will not get answer of this question in Lakshmikant, because Lakshmikant, as I've told you, it's a factual book. It's good book, but along with that, you have to focus. You have to go through class notes as well, right? So this was the question. I'll discuss the previous year questions in classroom program as well. Most appropriate definition of liberty. So there are so many options. Absence of restraint, and there are so many options, and the correct option was opportunity to develop oneself fully. Now, this, most of the students, they committed mistake in writing the correct answer, because most of them, they ticked the first option, that is absence of constraint. See, liberty is of two types: negative liberty and positive liberty. So negative liberty is absence of external constraint or external interference. But that is a very narrow definition of liberty. And that is why we have positive conception of liberty, that is opportunity to develop oneself fully. Existence of conditions because of which individuals can attain their fullest potential. So, from where this question was asked? This question was asked from the preamble. Now, preamble of the Indian Constitution mentions the word liberty, right? Liberty of thought, expression, belief, faith, and worship. So, you should know what is liberty. You should know what is justice. You should know what is equality, equality of opportunity, equality of status. You should know what is fraternity, what is secularism, what is democracy, what is federalism, what is constitutionalism. So of late, from last 3 4 years, UPSC is asking some questions on to test your conceptual clarity. So what is the appropriate definition of liberty was one question. Then another question was on democratic form of government. Democratic form of government. What are the characteristics of democratic form of government? Something like that. And so some options were given. Then another question was two times UPSC asked question constitutionalism. What does constitutional government means? And there were options. So it requires conceptual clarity. In future, UPSC might ask question on what do you understand by natural justice, what do you understand by rule of law, what do you understand by equality, what is the most appropriate definition of equality, equality of opportunity versus equality of outcome, formal equality versus substantive equality. So in Indian polity and constitution, in prelims, UPSC has started this trend of checking or testing conceptual clarity of the candidates. Right? Before that, UPSC used to ask question on, say, consider the following statement regarding Indian Parliament or money bill, right? Or say finance commission, how many members, what is the procedure of removal? So factual question UPSC used to ask. But now from 3 4 years, UPSC is asking certain conceptual questions as well. So that is why I said there are no shortcuts. You have to focus on conceptual clarity. Then this is about the graphical representation of previous year questions. Now let us discuss some of the questions of UPSC mains 2021, right? GS paper 2. Now my purpose is not to give you content because you are all this lecture is meant for beginners, those who are yet to start their preparation, right? So that is why I'll apart from giving you content, I will focus on giving you some answer writing tips. Fine? Right. So the first question is constitutional morality is rooted in the constitution itself and is founded on its essential facets. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. Now, this is the question. This question has two parts. Okay? Now, before I explain this particular question, let me tell you important answer writing tips. There are certain golden rules of answer writing, and I'm going to in classroom program we are going to take various tests as well, which will be evaluated by me only, not by the others, particularly GS paper 2, right? So क्या होता है, in exam students do not read questions carefully. Now, if you do not understand the question carefully, you will not be able to understand the key demand of the question. If you do not understand the key demand of the question, your answer is not going to address that key demand. So the first and the most important golden rule of answer writing is read question carefully. Read questions carefully. Very, very important. Very important. In the heat of examination, in hurry to complete the paper, candidates do not give enough emphasis, do not give enough emphasis or enough importance to reading the question. What candidates do, they will only read the question once and they'll feel, oh, the question is on constitutional morality, and they'll start writing. Don't do this mistake. Read question very carefully. Read question at least twice or thrice. Prepare some basic framework in your mind. based on your understanding of that question. Because you will understand, see, in answer writing, you have to address the key demand of the question. And you will be able to address the key demand of the question only if you understood the question thoroughly. And you will understand the question thoroughly only if you read the question very carefully. Very carefully. So read question at least twice and thrice, understand its key demand, prepare basic framework in your mind, and then only start writing. Got it? This is very important tip. So this question is about constitutional morality. The theme is constitutional morality. Fine. It has to see, UPSC has this tendency to ask questions within questions. So in some questions there will be two parts, in some questions there will be three parts, and some questions will be of only one part. This question has two parts. So first part says that constitutional morality is rooted in the constitution itself and is founded on its essential facets. So it basically explains some aspect of constitutional morality, that where it is rooted. Where does constitutional morality exist? It says that constitutional morality exists or rooted in the constitution itself. And what is the foundation of constitutional morality? From on which facets the constitutional morality is founded upon? So it says that constitutional morality is founded on the essential facets of the constitution itself. So, and the second question is, explain the doctrine of constitutional morality with the help of relevant judicial decisions. Now, the first sentence itself gives you enough hint of what to write in the answer. So, first, you're supposed to define what is constitutional morality, because this is what the question is all about. After defining constitutional morality, you're supposed to talk about whether it is rooted in constitution, how it is rooted in the constitution, and on which facets of the constitution constitutional morality is founded upon. Which are the facets, which are the elements, right? And then this will be the second element of your question. The third element will be giving judicial decisions, judicial examples of various cases of Supreme Court in which Supreme Court has used this doctrine of constitutional morality. Got it? The structure of the answer: define constitutional morality, define the facets of on which the constitutional morality is based. Okay, and the third, explain this with relevant judicial decisions. Now, why UPSC asked this question? I told you that UPSC tests your conceptual clarity. UPSC always asks questions around concepts. Constitutional morality is a concept. And from last 1 decade or so, Supreme Court of India, every now and then, has been using this doctrine or the concept of constitutional morality in its judgments. And that is why UPSC asked this question. Now, one more interesting thing about this question is UPSC in mains 2020 also asked question on constitutional morality. The nature of question was different, but the theme was same. What is constitutional morality and something like that, right? But it asked this question in ethics, GS paper 4. This year they asked this question in GS paper 2, but theme was same. Whether theme was repeated or not, did I tell you that UPSC never repeats questions, but it does repeats themes. Now, those candidates who religiously went through previous year questions, tried to answer those questions, solve those questions, for them it was very easy to answer this question. Those who did not, no, don't ever believe that, oh, this question was asked in 2020 or 2021. So next year it will not be asked, or next to next year it will not be asked. No. Theme is the same, right? Constitutional morality is a theme. And UPSC repeated this theme, but this time in different paper. Initially it asked in ethics. Now it asked in GS paper 2. So theme was repeated. So that is why it is very important to go through previous year question papers. It is very important to solve previous year question papers. Second important mantra, right? Fine. So what is constitutional morality? See, constitutional morality, basically it was a concept, it was given by British historian George Grote. And he defined, he was the first one who gave this concept of constitutional morality. You're not supposed to write this in your answers. Since this class is for beginners, I'm just telling you the concept, right? So he said that constitutional morality is paramount reverence. Sorry, constitutional morality, according to him, is paramount reverence. Paramount reverence. Reverence means respect. Paramount reverence to the forms of the Constitution. This is how he defined constitutional morality. But I'm sure, I mean, you're not supposed to go in the history, but I'm just for the sake of explanation, I'm telling you. So, according to him, constitutional morality is paramount respect, paramount reverence to the forms of the Constitution, or in simple terms, let me define constitutional morality for you. Constitutional morality basically means strict adherence or commitment to strict adherence and commitment to the ideals of the Constitution. Strict adherence, adhere karna, strict adherence or strict commitment to what? Strict adherence, being faithful to, having committed towards what? Strict adherence and strict commitment to the core values of the Constitution. What are the core values of Constitution? Can anybody tell me? Core values of Constitution like what? Like, what are the core values of the Constitution? Justice, liberty, equality, right? Fraternity, democracy, secularism, etc. What is constitutional morality? Constitutional morality means commitment to, being faithful to the Constitution in its true letter and spirit. Strict commitment to, respecting the ideals and principles contained in the Constitution. Core ideals and principles of the Constitution. Right? Got it? What is the constitutional morality? Constitutional morality is strict adherence and commitment to the core values of the Constitution like justice, liberty, equality, fraternity, secularism, democracy, so on and so forth. So, constitutional morality means respecting the Constitution and respecting the various ideals contained in the Constitution. Like we have personal morality. Every individual have their own moral principles. And the individual morality differs from person to person. Right? Some will say, oh, drinking is immoral. Some will say, oh, drinking is absolutely fine, and as long as I do not harm anyone else, drinking is absolutely okay. So, individual morality or personal morality or societal morality is different. And more often than not, it is based on stereotypes and prejudices. But the fact is that every individual is guided by some moral principles and values. Similarly, constitution is also guided by certain moral principles and values. So constitutional morality is commitment towards or strict adherence or strict commitment or being faithful to core values of the Constitution. Isn't it that difficult to understand? It's simple, right? But we have to give enough respect to the subject. You have to give enough respect to the concepts, and then only you will be able to write answer to the questions like this. Okay? Sorry. Oh, where has it gone? Yes. Fine. So in first 3 or 4 or 5 lines, you have to define what is constitutional morality. Now, see, as far as India is concerned, the constitutional morality as a word or as a concept was for the first time used by Dr. B.R. Ambedkar. It was used in the context of Constituent Assembly debate in 1948, November 1948, when there was some debate on incorporating certain administrative details in the draft constitution. Draft constitution incorporated certain detailed administration structure in the constitution itself. So some of the members of Constituent Assembly, they decide that, oh, why you are adding all these administrative details in the constitution itself? Let the legislature decide what kind of administration India should have. At that time, Dr. B.R. Ambedkar, he took recourse to the concept of constitutional morality. Right? He said that no, for the sake of constitutional morality, you should incorporate the administrative details in the constitution itself. You cannot trust the wisdom of legislature, because tomorrow the legislature might convert India from a parliamentary form of government to the presidential form of government, and in day after tomorrow it might convert into a totalitarian or dictatorship. Right? So that is why he said that for the sake of constitutional morality, you should incorporate certain essential aspects in the constitution itself. You cannot leave it to the future generation, or you cannot leave it to the legislature for that matter. Right? I mean, he did not believe that constitution should be static. Constitution should be dynamic. He said that certain essential things should be incorporated into the constitution itself. So at that time, so in this question, you are supposed to write views about Dr. B.R. Ambedkar. Definitely, views of Dr. B.R. Ambedkar on constitutional morality. You know what he said? He said that constitutional morality in India is not a natural sentiment. He says that constitutional morality in India is not natural sentiment. It doesn't come naturally in Indian people. Constitutional morality has to be cultivated amongst the Indian people. And then he says that democracy in India is a topsoil. He said that democracy in India is a top dressing on Indian soil, which is essentially undemocratic. I repeat, Dr. B.R. Ambedkar, while discussing constitutional morality, he argued that democracy in India is top dressing on Indian soil, which is deeply undemocratic. ऊपर से democratic लगता है, नीचे से undemocratic है. Why? Because Indian people lack constitutional morality. So he argued that constitutional morality is not natural sentiment. You have to cultivate constitutional morality amongst the people. Right? By various ways and means. ये हो गया, right? Now the next question is, so constitutional morality is rooted in the constitution itself, right? Why? Because constitutional morality is strict commitment to the constitutional values. Constitutional values are contained in the constitution itself, in preamble, so on and so forth. So the second part is constitutional morality is founded on essential facets of constitution. So next sentence, write down which are those essential facets on which constitutional morality is founded. So constitutional morality is founded on, what are the essential facets? Can you tell me what are the essential facets? What are the essential facets? Preamble? Oh, sorry. What are the essential facets? Preamble? Yes, preamble embodies the basic philosophy and ideals contained in the constitution, right? So this is important facet. Then next, fundamental rights. Fundamental rights. Then next, directive principles of state policy. These are the three important facets upon which the constitutional morality is based. Right? Why preamble? Because preamble embodies the basic philosophy of the constitution. Why fundamental rights? Because fundamental rights guarantees certain essential rights which are very important for an individuals to attain their fullest potential, to ensure all-round development of their personality, as well as to limit the the government and to ensure political democracy. Directive principles of state policy is very important to establish social and economic democracy, because political democracy without social and economic democracy is meaningless and useless. So these are the facets on which constitutional morality is based. You explain. So in the first paragraph, you have explained what is constitutional morality, the background of constitutional morality. In the second paragraph, you have written about the facets upon which constitutional morality is based. And the third paragraph, what will you write? What will you write? In the third paragraph, you will write about judicial judgments. So you have to break down the question into different aspects and different paragraphs and write the answer of those aspects systematically, one by one, in a logical coherence, through a logical coherent manner. Judicial judgments. Yes, there are so many judicial judgments in which Supreme Court had you have to write down that why Supreme Court has used the concept of constitutional morality. Supreme Court has used the concept of constitutional morality to interpret the nature, scope, and extent of the fundamental rights of the citizens. Supreme Court of India has taken recourse to the concept of constitutional morality to examine the nature, scope, and extent of the fundamental rights guaranteed by Part 3 of the Indian Constitution. Then Supreme Court has also taken help of the concept of constitutional morality to determine the constitutional validity of various laws passed by the parliament, and as well as to determine the basic philosophy behind various provisions of the constitution. So Supreme Court has used the concept of constitutional morality in giving its judgment about regarding nature, scope, and extent of fundamental rights, both group rights, individual rights, minority rights, so on and so forth, constitutional validity of various laws, various constitutional amendments passed by the parliament, so on and so forth. Right? So you have to write down why Supreme Court has used this concept. Then in which cases Supreme Court has used this concept of constitutional morality. There are various cases, famously being Naz Foundation versus Government of NCT Delhi case of 2009, right, wherein the Delhi High Court decriminalized Section 377 of Indian Penal Code, right? And in that case also, Delhi High Court took recourse to constitutional morality. The similar, then the next case, which was related to the same particular theme of homosexuality or decriminalization of homosexuality, was Navtej Singh Johar case. Navtej Singh Johar and others versus Union of India and others case of 2018. Now, in this case, precisely, Supreme Court said that constitutional morality, listen to me very carefully, constitutional morality should prevail over societal morality or majoritarian morality. What did Supreme Court say? Constitutional morality should prevail over the societal morality, majoritarian morality, or public morality. Because public morality can be based on prejudices and stereotypes. Right? For example, public morality says that homosexuality is unnatural. But constitutional morality says that every individual has a right to determine his or her sexuality, which is a part of right to privacy of every individual. Right? So right to privacy, which includes right to determine your own sexuality or to choose your own sexual partner, is a part of right to life and personal liberty, which is a fundamental right, which is a part of constitutional morality. And that is why constitutional morality should always prevail over societal morality, majoritarian morality, or public morality. If you go according to the public morality, you will not be able to defend the rights and liberties of the people. And as Dr. Ambedkar said, that constitutional morality in India is not a natural sentiment. It doesn't exist naturally within Indian people or Indian society, because Indian society is casteist society. So it has to be cultivated. Right? And Supreme Court of India is precisely doing this. It is trying to cultivate constitutional morality amongst Indian people. So this was the case. Then there was another question, Sabrimala temple entry case, which is officially known as Indian Young Lawyers Association and others versus State of Kerala and others case of 2018. Even in this case, Supreme Court took recourse to or took help of the concept of constitutional morality to examine the nature, scope, and extent of right to religion and right to worship and right to privacy, right to freedom of speech and expression, right to equality, etc. of women. So, by taking help of constitutional morality, Supreme Court ruled that ban of women of the age group of 10 to 50 in Sabrimala temple is violative of concept of constitutional morality. Public morality says that women should not be allowed to enter into the temple. That is based on public morality. Constitution, Supreme Court said, "Oh, you can't go on the basis of constitution, on the basis of public morality, right? Public morality will say lynch women who enter into the Sabrimala temple, lynch Muslims who do not follow the majoritarian ideals, right? So basically, you have to go on the basis of constitutional morality. So taking help of constitutional morality, Supreme Court allowed women to enter into Sabrimala temple. Right? So these are some of the even basics. Even Kesavananda Bharati versus State of Kerala, case of 1973, which is a historic and landmark case in which Supreme Court gave the doctrine of basic structure. Even in that case, Supreme Court touched, even though not in detail, touched to the concept of constitutional morality. It says that, it argued that constitutional morality prescribed that the power of parliament to amend the constitution cannot be unlimited, they cannot be unfettered. The power of parliament to amend the constitution has to be limited according to the concept or principle of constitutional morality. And this is how you can, and in the end, you can write down that the significance of the constitutional morality, that constitutional concept of constitutional morality has enabled the Supreme Court of India to broaden and deepen the rights and liberties of the people. Before this, you have to write down about certain weaknesses of the concept as well. So try to write multidimensional answer. What is the weakness of concept of constitutional morality? See, constitutional morality is nowhere defined in the Constitution. Constitution of India nowhere uses this term constitutional morality. Constitutional morality as a concept is vague. It is nowhere defined in the Constitution. There is no universally accepted definition of constitutional morality. So what amounts to the constitutional morality differs from judges to judges, right? So the concept of constitutional morality is very dicey. It is very vague, and it depends on the subjective interpretation of the constitution of individual judges, and that makes the constitutional morality very challenging concept, a very dangerous concept in that sense. No, it is not dangerous, but it is a very vague concept, because what amounts to constitutional morality differs from judges to judges. So what suggestion you can say? Yes, constitutional morality is a very useful concept, but there should be a consensus which should be evolved by Indian judiciary or by Supreme Court to define what constitutional morality is, where it can be, where can the constitutional morality can be used, the concept of constitutional morality can be used, in what concept can be used. So some kind of clarity is needed over the nature, scope, and extent of the concept of constitutional morality. So you are looking at constitutional morality through critical angle as well. In fact, the former Attorney General of India, once he said that, I hope constitutional morality dies. Why? Because he said that it's a very vague concept. Everything can be justified on the basis of constitutional morality. Everything can be nullified on the basis of constitutional morality. But what is constitutional morality? Constitution nowhere defines it. It's vague. It depends on judges to judges. It differs from judges to judges. So let us have some kind of understanding, some kind of consensus about constitutional morality. Have some guidelines about constitutional morality. This you have to write down. And then in the conclusion, write down that how the concept of constitutional morality has enabled the Supreme Court of India or a higher judiciary to broaden and deepen the rights and liberties of the citizens. Right? Fine. So you try to write multidimensional answer. Try to bring in as many aspects as possible. Because, out of 10, you have to try to maximize your marks. And this will come only when you will enrich your answer, when you will write comprehensive answer, multidimensional answer. The next question is, discuss desirability of greater representation to women in higher judiciary to ensure diversity, equity, and inclusiveness. 150 words. You have to answer this in 150 words. Now again, why UPSC asked this question? Okay. See, GS paper 2, basically, some of the questions of GS paper 2, they are based on current affairs. And this particular question is directly related to the current affairs. See, Chief Justice of India, Ramanna, when he became Chief Justice of India, or even before that, he is voicing this concern of a lack of representation of women in higher judiciary, in Supreme Court and High Court. And there were so many articles which came in the Hindu as well as in Indian Express about this particular topic. Lack of gender equity, lack of women's representation in higher judiciary, right? Okay. So the question is about desirability of greater representation of women, that we need to increase or enhance the representation of women in higher judiciary. Now, what is higher judiciary? Many of the students might have written about the district courts. Higher judiciary includes Supreme Court and 25 high courts only. Higher judiciary does not include lower or subordinate courts. So you have to limit your answer to Supreme Court and High Court, right? So now this question demands certain data to be given. You have to give certain facts, right? So let me tell you about some interesting facts. So question is about desirability of greater representation of women in higher judiciary. So first you have to talk about what is the representation of women in higher judiciary. You have to give some data, right? So let me tell you this data. And this data was quoted by Chief Justice of India Ramanna when he voiced his opinion about increasing the representation of women. So from there, if you have followed a particular newspaper, you could have got that fact and you could have used that fact in this answer, right? So out of 33 judges of Supreme Court, presently only 4 judges are women, which is approximately 12%. Out of 33 judges of Supreme Court, only 4 judges are women, which is only 12%. What is the population of women in India? Approximately, percentage-wise, half. Approximately half of the population of India is women. So any institution to be representative should give 50% representation to women. 50%. What is the reality? How much is the representation of women in current Supreme Court? 12%. What should be the ideal? 50%. 12% is very meager. It is very abysmal, right? Okay. And that is why former judge of Supreme Court Indira Jaising, she called Supreme Court as old boys club. Old boys club. That Supreme Court is old boys club. Women are not allowed to enter into this exclusive club dominated by, so Supreme Court is male dominated institution, right? Okay. Now, out of these 4, 3 judges were appointed recently in September 2021. Meaning before that only one judge, there was only one women judge. Okay. Now, since independence, we have only 11 women judges out of 256 judges. This is the data of 2021. Out of 256 judges of Supreme Court, only 11 judges have been women. If you calculate this percentage, it is only 4.2%. Right from 1950 when Supreme Court was established. 4.2%. Isn't it low? Extremely low. Yes. Currently, 12%. The first women judge of Supreme Court was appointed when, He was appointed in 1989. She was Justice Justice Fatima Bibi. 1989. 39 years after the establishment of Supreme Court, the first women judge was appointed, Justice Fatima Bibi. And since independence, only 11 women judges have been appointed. This is about what? This is about what? Now you have to write about High Court as well. High Court. Now there are 25 High Courts. Out of 25 High Courts, only 11.5% judges. Only 11.5% judges of 25 High Courts are women. How much? 11.5%. Presently. What about Supreme Court? 12%. 4 out of 33. So you have in the first paragraph itself, you should write down that judiciary is one of the, in the introduction, you should write down why judiciary, how judiciary is very important institution. That judiciary is one of the most important institutions in Indian democracy, which plays very important role of guardian of Indian constitution as well as guarantor of the fundamental rights of the citizens. Considering the importance of the judiciary for Indian democracy, it should represent the diversity, gender diversity of India. Unfortunately, the data suggests that the judiciary is there is lack of enough representation of women in judiciary. This can be seen from following data. Give this data, right? Now say that now since this is the case, that is why there is a desirability of greater representation of women in higher judiciary for the sake of inclusion and equity, so on and so forth. That is given. Now, what will happen if you do this? Why women should have greater representation? First of all, this data. Now, you have to write down that, giving greater representation to women in higher judiciary will motivate more and more women, particularly poor women, to knock the door of justice. So that will enhance the access to justice in India, right? So more and more women will be motivated to approach the Supreme Court as well as high courts to demand enforcement of their rights, and that will broaden the justice delivery system. First, second, giving more representation to women in judiciary will also ensure most balanced and gender sensitive approach in various cases, particularly women related cases. If you have more women in a particular bench regarding various cases which affect women, like say Sabrimala temple case, or say a sexual violence or sexual harassment case, that will enhance the different perspective, that will give in a different perspective in that cases, and that will increase the quality of justice delivery mechanism, right? So giving more representation to women in higher judiciary will bring in gender sensitive approach in various decisions given by higher judiciary. Then it will also motivate, giving more representation to women in higher judiciary will also motivate more and more women to join Indian judiciary. It will motivate more and more women to become judges, to become lawyers and become judges, right? Then another aspect can be, that giving more representation to women in judiciary will also help in increasing the representation of women in other two branches of government, like parliament and executive. That will act as a springboard to increase the representation of women in other two branches of the government, right? So these are the benefits. Okay? So you have to write down what will be the benefit of increasing the women's representation in judiciary. Now, how to do that? Third paragraph, how to increase the representation of women in higher judiciary. Now again, you have to take recourse to the Justice Ramanna's speech, or he gave data. He said that, out of 17 lakh Advocates in India, only 15% advocates are women. So it means that very less women are joining legal profession. Okay? Very less women are joining legal profession, maybe because of patriarchal attitude of clients preferring male advocates. So this is less. The percentage of women advocate is extremely low. So that is why he said that, and you don't have to quote necessarily him. So you can just write as suggested by current Chief Justice Ramanna. We need to give certain reservation. We need to give certain reservation. We need to reserve certain seats for women in various law colleges, law institutions, and law universities. So once you reserve certain proportion of seats for women in law schools, in law universities, then more and more women will enter into law profession, more and more women will become advocates and judges. They before becoming judges, they are advocates. So first increase women advocates. How can you do that? By reserving certain seats in law schools and law universities first. Okay? Then another can be, one is reservation at the level of education, law as a profession. Second will be reservation at the level of judiciary itself. Reserve certain proportion of seats. Reserves one third of the seats to women in higher judiciary. Make it mandatory. Amend the constitution and reserve one third seats to women in higher judiciary. There is one women's reservation bill which seeks to give one third representation to women in Lok Sabha and state legislative assembly is pending, right? So similarly, we should also have reservation to women. If women can have reservation, if there is an argument in favor of reservation of women in Lok Sabha and state legislative assemblies, why can't we can amend the constitution and give one third of the reservation, reserve one third of the seats to women in Supreme Court as well as in 25 high courts? This can be the solution. Then another solution can be, about judicial infrastructure. Again, Justice Ramanna, he basically he directed one survey, right? So that survey was conducted in 6,000 trial courts. So out of 6,000 trial courts, the study revealed that out of 6,000 trial courts, 22% trial courts did not have women toilets. So we can talk about infrastructure, improving the judicial infrastructure to make it more gender sensitive, so on and so forth. And this is how you can conclude your answer, that giving more and more representation to women is going to make our judicial system very inclusive, broad base, and equitable in gender sense, right? Fine. So this is how you're supposed to write your answer. Second question. Third, how have the recommendations of 14th Finance Commission of India enabled states to improve their fiscal position? Now, this question is a very dicey question, because this question can be asked in GS paper. This question, the answer can be written from the point of view of GS paper 3 as well, Indian economy. So in this question, you are supposed to control your urge to write answer from Indian economy perspective. Why? Because the question is asked in GS paper 2. So you are supposed to write your answer from the point of view of Indian polity and Indian constitution, not from the point of view of Indian economy, right? And the question is on 14th Finance Commission, which was set up in 2013, which gave recommendation in December 2014. Y.V. Reddy was the chairman of 14th Finance Commission. Many of the students whom I know, they wrote recommendations of 15th Finance Commission, which is the latest Finance Commission. Right? So 14th Finance Commission gave recommendation from 2020 to 2015 to 2020. So 15th Finance Commission already submitted its report. UPSC, instead of asking 15th Finance Commission recommendation, it asked 14th Finance Commission recommendation. Right? So that is why we should not try to predict UPSC. You will definitely fail in that. You should focus on your preparation, reading what is required, practicing answers. That is it. Predicting questions should not be, you should not waste your time. Right? So 14th Finance Commission. So in first question, write down about 14th Finance, write down about Finance Commission. In one line, Finance Commission is a constitutional body established under Article 280 of the Indian Constitution. 14th Finance Commission was set up in 2013 under the chairmanship of Y.V. Reddy. It gave recommendations for the year 2015 to 2020 in 2014. Right? This should be the second sentence. The following recommendations of the 14th Finance Commission enabled states to improve fiscal position. Following, number one, right? 1, 2, 3, 4, finish. Very simple. So here you can write down that, you know, the 14th Finance Commission for the first time recommended that the state's share in the central's divisible pool of taxes should be increased from 32% to 42%. 10% increase. See, central government, there are certain taxes. Central government collects taxes. The certain share of those central taxes, they are shared with the states. This is called as divisible pool of central taxes. Right? So, before 14th Finance Commission, the central government used to share 32% of the central taxes with the states. Now 14th Finance Commission recommended that the state share in the central's divisible pool should be increased from 32% to 42%. So it recommended 10% increase, which is highest ever, which is highest ever so far. So this has improved, this has definitely enhanced the fiscal position of all the states for that matter, because if the size of cake increases, more and more people, more and more states will be able to benefit from that, right? And the 14th Finance Commission recommended that tax devolution, tax transfer should be the primary mode of devolution. See, tax devolution is unconditional devolution. Tax transfer is unconditional and untied devolution. There are no conditions, there are no strings attached when it comes to tax devolution. So when 14th Finance Commission has recommended to transfer 42% of the central taxes to the states, then there are no conditions attached, right? So Finance Commission, by recommending that the tax devolution or tax transfer should be the primary mode of transfer from central government to the state government, it has enhanced the fiscal autonomy of the respective states, and hence strengthened the fiscal federalism of India, and helped and enabled to strengthen fiscal federalism. So what you're doing, you are using the concepts of Indian polity. You're using the terminology of what? Indian polity. Sorry. Right? You are using the terminology of Indian polity, fiscal federalism, cooperative federalism. Use these terms. Right? So this is the first. It has strengthened, or it has helped to strengthen fiscal federalism. Government has accepted this recommendation. Second, for the first time, the 14th Finance Commission used the data of 2011 population census. This will help you in future as well. Okay? That is why I'm discussing it in detail. Okay? Population census. See, before 13th Finance Commission gave 25% weightage. 25. See, there are two types of transfers: vertical transfer and horizontal transfer. Vertical transfer is transfer from central government to the state government. 42% central taxes should be transferred to the state government. This is called as vertical transfer, right? But there is horizontal transfer as well. So how this 42% should be distributed amongst 28 states of India? How? For this, there is some formula. And this formula is based on various criteria, right? One of the criteria is population. So 13th Finance Commission, right? Finance Commission before this, it gave 25% weightage to Which population? 1971 census population. But the 14th Finance Commission, it gave 17.5% weightage to 1971 census, population census, and 10% weightage to 2011 census, population according to 2011 census, 10%. So total weightage was given, it was increased to 27.5. So what is the difference? What is the difference? 13th Finance Commission gave 25% weightage to population, but which population? 1971 census, right? But 2014, the 14th Finance Commission for the first time gave 10% weightage to 2011 census. Now, how it has affected the different states. So it means that those states who have more population in 2000, according to 2011 census, will get more funds from the central taxes, and those states which have less population, they will get less funds, right? And that is why this particular mechanism of using 2011 census was criticized by southern states. Why? Southern states said that in 1971 you adopted population control policy, family control, family planning policy, and we have been successful in controlling the population. And now what you're doing, you are using 10% weightage, giving 10% weightage in transferring central taxes to the states according to 2011 census. It means that those states who have been successful in controlling their population, they will get less funds. So due to using this 10%, giving 10% weightage to 2011 census has affected the southern states negatively, and it has given more, it has benefited the North Indian states, more or less North in, not all, but some of the North Indian states who have more population according to 2011 census, right? Second. Third, for the first time in that formula, the 14th Finance Commission gave weightage to forest cover. Forest cover. It gave 7.5% weightage to forest cover. How it has impacted the different. So the question is about how the recommendations of 14th Finance Commission have affected the fiscal positions of various states. So it means that those states who have more forest cover, or who have preserved their forest cover, will get more funds, and those who have less forest cover, right, or who have who have used the forest cover for industrial and construction activities, they will get less funds. Yes, fine. This is the second. Okay. So then the next is the 14th Finance Commission increased the weightage given to area, from 10% to 15%. Weightage given to area, geographical area. So see, horizontal transfers from central government to the state government is based on formula like population, forest cover, area. So how this incorporation of various elements have affected the fiscal position? That is what you are supposed to write. So area, I mean, more the area of the state, more the funds you will get. So meaning, the geographically large areas like Rajasthan, large states like Rajasthan, Maharashtra, they have more chances, not necessarily, they have more chances to get funds, and those who have less area, small states like Sikkim or other states, they will get less funds, more or less. But there is no direct connection, there is no binary. For example, state might be big in area, but it might not have forest cover, so there it will lose. But more or less, there it can benefit, it might have benefited them, right? Okay, so these are the recommendations. Then another important recommendation is that the 14th Finance Commission recommended restructuring of centrally sponsored schemes. Now, centrally sponsored schemes are framed by the central government in the subjects belonging to the state list. Centrally sponsored schemes, they are framed by whom? Central government. On which subject? Subject belonging to the state list. Right? And the expenditure is to be borne by both central government and the state government. State government will frame the scheme, and the scheme will be implemented by the state government. Scheme will belong to the which subject? More or less state list. For example, NH, National National Rural Health Mission. This is a centrally sponsored scheme. Now, centrally sponsored scheme, health is a state subject mentioned in the 7th schedule of Indian Constitution. So, who should frame the schemes regarding the health, which is a state subject? State government. But the central government framed the scheme on a subject belonging to the state list, for which states have to reserve some funds, right? So, centrally sponsored scheme violates the principle of cooperative federalism or fiscal federalism. Why? Because let the state governments devise the schemes on the basis of their own requirements. Why the state central government should suggest the schemes on the subjects belonging to the state list? It violates the principle of federalism, right? So that is why the 14th Finance Commission recommended, that is why various commissions, Punchi Commission, Sarkaria Commission, BK Chaturvedi Committee, and 14th Finance Commission also recommended restructuring of centrally sponsored scheme. Either they should be abolished. It did not, it did not recommend to abolish the centrally sponsored scheme, but it recommended that the centrally sponsored schemes should be kept as minimum as possible to give fiscal autonomy to the states, so that they can spend funds on the basis of their own requirements. For some states, health might be an important priority, but for some states, instead of health, education might be a priority. For states like Kerala, neither health or education might be a priority for them. Industrialization might be a priority. So why you are framing the schemes? The one size fits all approach is not good. So this restructuring of centrally sponsored scheme has also enabled strengthening the cooperative federalism, right? Um, then another was regarding special category status. 14th Finance Commission says that argued that or recommended that special category status given to certain tribal and hilly areas should be backward states should be abolished. Okay. Then the another important recommendation which most of the candidates must have forgotten to write is regarding the recommendations regarding Panchayati Raj institutions and urban local bodies. The 14th Finance Commission recommended multifold increase in the funds to be given to or to be devolved to local bodies. Panchayati Raj institutions and urban local bodies. It's recommended 277% increase of the funds to urban local bodies. Can you imagine? 277% increase, and thereby it has strengthened the cooperative federalism. So you have to write this question in from the polity perspective. Okay. The next is about Human Rights Commission. UPSC has asked about a question about Human Rights Commission previously as well. This time it again asked question on Human Rights Commission, but through different different sense. Okay. Then it also asked question on National Commission on Women. Previous year it asked question on National Commission on Women. This year it asked question on Human Rights Commission, National Commission of Women, National Human Rights Commission, National Commission for Protection of Children's Rights. These are what? These are what? Statutory bodies established under law of the parliament. So though the Human Rights Commission have contributed immensely to the protection of human rights in India, yet they have failed to assert themselves against the mighty and powerful, analyze their structural and practical limitations, suggest remedial measures. So what is the theme? Theme is about NHRC, National Human Rights Commission. Now the question says that, first statement says that, yes, Human Rights Commission has contributed immensely to the protection of human rights in India to some extent, but still it has failed to assert themselves against mighty. So in some extent, to some extent it is successful, to some extent it has failed as well. First sentence. Okay. Second sentence says that, analyze their structural and practical limitations which are contained in the law itself, and practical limitations, lack of financial autonomy, so on and so forth, and suggest certain remedial measures. Three elements: positives of NHRC, then structural and practical limitations, second, third, remedial measures. This should be your answer. So write down about NHRC that NHRC is a statutory body established under Protection of Human Rights Act 1993. This should be your first sentence. Write down something about NHRC, right? NHRC is a statutory, it's an independent quasi-judicial statutory body established under Protection of Human Rights Act 1993, right? And it acts as a human rights watchdog in India. A basic aim, two, three sentence write down about human NHRC. Its basic aim is to provide institutional mechanism to protect, promote, and preserve the human rights in India, and to redress the grievances of the people as far as violation of human rights is concerned. Two, three lines about NHRC. Then successor. So in past, write down about some positive things. In past, National Human Rights Commission have played very important role in protecting the human rights of India. Then write down about where, in which cases. So National Human Rights Commission have played very important role in dealing with various cases of human rights regarding starvation deaths in Bolangir, Kalahandi and Koraput districts of Odisha, then custodial torture and violence in observation homes of Karnataka. It has also successfully dealt with various social evils like bonded labor, child labor, so on and so forth, and various recommendations of NHRC regarding all these social evils have been accepted by the government, and they have went in a long way to protect and promote the human rights of the poor and disadvantaged section of society. Then give certain case studies that how the NHRC took by taking suo motu cognizance of violence during Godhra riots in 2002. In 2002, so NHRC have protected the rights of the minorities. Right? See, do not write politically biased answers. Do not name parties. Do not name persons. As a civil servant, you should be unbiased. You should be politically neutral, and you should speak the language of constitution. You're not supposed to write answers like politicians, right? You're not supposed to write ideological answers, as in answers from left angle, from rightist angle, from Congress center left angle. No. For you, the only book you should follow as a civil servant is what? Constitution of India, right? Then you can also write about how the NHRC complaint to NHRC exposed the multi-crore pension scam in Haryana, right? So this is how by all this. So write down some examples where NHRC has played positive role, and then write down that how NHRC has played very important role in educating and spreading awareness about human rights. है ना, right? ये तो ठंडा हो गया. I'm speaking continuously. Anyways, so positives, you have written positives in 4 to 5 lines. Okay? Then write down about structural and practical limitations. What are the structural and practical limitations? Despite doing, to some extent, despite performing decent role, functioning of NHRC has been plagued by following structural and political limitations. Number one is about the fact that NHRC is only recommendatory body, meaning NHRC is only advisory body. It is only advisory. It can only advise. Recommendations of NHRC are only advisory in nature. Recommendations of NHRC are not legally binding on the government. This is the biggest structural and practical limitation on NHRC. NHRC can only give recommendations, and the governments, they may or may not accept those recommendations. Then NHRC lacks power to enforce its orders. It can only give orders or give recommendations. It lacks power to punish those civil servants who fail to implement its recommendations. It cannot do anything. It can only recommend that this public servant is not doing his duty to protect human rights of people, and hence some action should be taken against this public servant. It can only recommend. It cannot itself punish the public servant. It has to depend on central government, state government, and judiciary. So it lacks teeth. to bite. And that is why NHRC has been criticized as toothless body. It has been criticized as what? Toothless commission. Sorry, toothless commission. Because it does not have any power to take any action against recalcitrant civil servants or public servants. It cannot, its orders are not legally enforceable. It is only advisory body. Its recommendations are not legally binding on government, and various governments have refused to accept various recommendations of NHRC. They are put the recommendation of NHRC in the dustbin, right? So this is the big. So that is why toothless. In fact, Justice V.R. Krishna Iyer, once called NHRC as the biggest post office of India. Biggest post office of India. Serving no practical purpose. Collecting letters, transferring, giving recommendations to the government, taking the letters in the sense of government's response, biggest post office. Some have called NHRC as National Commission on Inaction. Now, these are certain keywords. You have to underline this. Okay? First, practical limitation. Okay? Second is about politicization of appointment process. What? Politicization of appointment process. See, NHRC is a 6-member board. There are 6 full-time members in NHRC. As last amended, NHRC has 6 full-time members. Okay. Now, these 6 members of NHRC are appointed by the President of India, on the basis of recommendations given by 6-member search and selection committee. NHRC has 6 full-time members. These 6 full-time members are appointed by President, not on the basis of his own individual judgment, on the basis of recommendation given by 6-member search and selection committee. Now, the 6-member search and selection committee consists of following members: Prime Minister, who acts as a chairperson; Speaker of Lok Sabha; Deputy Chairman of Rajya Sabha; Leader of Opposition in Lok Sabha; Leader of Opposition in Rajya Sabha; and Union Home Minister. So if you look at the composition of search and selection committee, it is dominated by executive. It is dominated by government. How? Prime Minister, government; Home Minister, government; Speaker is also biased. Speaker is also of government. Right? 3 members out of 6 members are, they belong to the government. Right? So that led to the politicization of appointment process. Right? The search and selection committee does not have representation of civil society members, for that matter. Right? Civil society members should be given representation in the search and selection committee. The chairman of NHRC has no say in this committee. He should also have some say in appointing the members, in recommending the names of the members, not appointing. Right? So that led to politicization of appointment process. See, NHRC consists of 6 members. Out of 6 members, 3 members should be those having special knowledge and practical experience in the field of human rights. And out of these 3 members, 1 should be women. So 3 members should be those who should come from civil society, those who are social rights activists, civil rights activists. Sorry, those who have knowledge about human rights. Instead of appointing these members who have special knowledge and practical experience in human rights, government has appointed former bureaucrats as this in these 3 members, right? For example, in 2000, so NHRC has been reduced to a post-retirement destination for loyal civil servants or loyal judges, ex-judges. It is considered as a rehabilitation chamber for not rehabilitation, but it is considered as a post-retirement chamber for whom? Ex-bureaucrats who have been loyal to the government. Right? So that has led to politicization of appointment process. If the members are if the members, they belong to the political party or they are loyal to the government, NHRC has to take action against violation of human rights by whom? Public servant. Public servant belonging to who are part of government, permanent executive. So if the members themselves are political personalities, how can NHRC perform its role, right? Okay. For example, in 2004, ex CBI director was appointed as member of NHRC. Then ex NIA chief has also been appointed as a member of NHRC. So that this is also a problem, politicization of appointment process. Okay. Then another structural limitation is about related to 1 year clause. There is 1 year clause. What is this 1 year clause? See, Protection of Human Rights Act, as amended in 2019, it says that National Human Rights Commission can only it can only investigate the case of human rights violation only within 1 year of its occurrence. Meaning, after 1 year of its occurrence, in its occurrence of any human rights violation case, you, National Human Rights Commission will not investigate that case. Now, there are many instances wherein people they do have fear of not approaching NHRC due to social backlash, so on and so forth, right? So this 1 year clause serves as a structural as well as practical limitation on power of NHRC to protect the human rights of the people, particularly of weaker and disadvantaged section of society, right? So NHRC can only deal with the cases which are of which have occurred within 1 year. After 1 year of its occurrence, NHRC will not deal with that case. So this is a practical limitation. Okay. Now there is one committee you have to write down about this: Justice Ahmadi Committee. Justice Ahmadi Committee, which was a high level advisory committee set up by human NHRC itself. It gave various recommendation it gave recommendation in 1999 regarding how to strengthen NHRC. So while giving suggestions, remedial measures, you have to give recommendations of this Justice Ahmadi Committee and how that this recommendation should be accepted. But first, write down limitations. First limitation is about it is advisory in nature. It lacks teeth to bite. It does not have any power to issue legally enforceable order and punish the recalcitrant civil servant. Politicization of appointment process. 1 year clause. Then it has also limited powers with respect to armed forces. National Human Rights Commission has very limited powers to deal with cases of human rights violation by armed forces. And most of the cases of human rights violation, they are related to the armed forces. Right? When it comes to human rights violation cases of armed forces, NHRC can only demand report from the government. After receiving report, it cannot do anything. So it has very limited powers when it comes to dealing with the cases of human rights violation by armed forces. So this is also practical limitation. Then there is the structural limitation. Then there are practical limitations about lack of financial and administrative autonomy. Right? So for example, NHRC does not have power to appoint its own staff. Its staff comes from the central government and the state government. The staff is sent on deputation, right? Then it lacks financial autonomy. NHRC is dependent on central government for funds. Now, if NHRC is dependent on the central government for funds, how it can give orders against the central government? What will central government do? Central government will reduce its funds. So it should have. So in suggestions you can give, you can write that the expenditure of NHRC should be the expenditure of the NHRC should be charged upon the consolidated fund of India, as in it should be part of non-votable expenditure during like in case of say UPSC, like in case of CAG, like in case of other constitutional bodies. Right? It should not depend on the government for its funds. Okay? Lack of administrative autonomy. Then it does not have its own prosecution and investigation wings. It does not have its own prosecution and investigation wings. It means that it does not have its own police force. It depends on the central government of police officials, the state central government police officials who come on deputation, and they don't have any loyalty towards NHRC because they know that they are here only for a limited period of time. They always aim to go back into their state cadres. So they don't have that willingness or that wish or that enthusiasm to function well, right? So these are the weaknesses. So in remedial measures, here only write down weaknesses, remedial measures. The recommendations of NHRC should be legally binding on the government, except in exceptional cases. Number one. Second, NHRC can be converted into a constitutional body if you give constitutional status. NHRC should be conferred constitutional status. If you give constitutional status to NHRC, the power and prestige, the prestige, it will have a symbolic meaning, if not practical meaning, right? It will have a symbolic meaning of enhancing the prestige of NHRC. See, it is not necessary that if you give constitutional status to NHRC, it means that NHRC will become powerful. Even Election Commission of India is a constitutional body, but it is not functioning as a powerful body in real sense of the term. So it is not necessary. It is not necessary. See, giving constitutional status is necessary to strengthen NHRC, but it is not sufficient. Along with that, there are other reforms which needs to be taken. So, second thing, right? Third, politicization. To prevent politicization of appointment process in search and selection committee, the chairman of NHRC as well as civil society members should be given representation, right? Then 1 year clause should be. So while giving remedial measures, you should talk about Justice Ahmadi as suggested by Justice Ahmadi committee set up by NHRC in 1999. Following remedial measures can be undertaken. 1 year clause should be removed. 1 year clause should be removed. This is what recommended by Justice Ahmadi committee. Okay. Then NHRC should be given power to investigate the cases of human rights violation by armed forces. It should be given its own investigation and prosecution wing. Its expenditure should be charged upon Consolidated Fund of India, so on and so forth. So you have given enough 4 to 5 suggestions. You have given 4 to 5 practical limitations in the introduction. You have written about positive things about NHRC and certain positive contributions of it. And in the conclusion, write down if the above remedial measures are undertaken, then NHRC will go a long way it will go a long way in strengthening the NHRC and thereby promoting and protecting the human rights of Indian citizens, particularly of those who are poor and marginalized. Got it? Right? So this is how, see, so the content is, there are so much of content to write. Okay? But what matters is how you systematically write that content. And that is why answer writing is very important. So always divide your answer into different paragraphs. Introduction, then body and conclusion. This is all, every teacher says this, but I will say divide your answer into paragraphs based on the question. If the question has 3 elements, divide your question into 3 paragraphs, right? Or first paragraph can be introduction, then second paragraph will deal with first element, third paragraph will deal with second element, and fourth paragraph will deal with fourth element, and then last 2 lines conclusion, right? So divide your answer into small paragraphs. Then the last question of today is, to what extent in your view Parliament is able to ensure accountability of the executive in India? Now this is very easy question. Very easy question. And I believe why UPSC has asked this question is because of ineffectiveness of Parliament. So this question is effectively related to decline of Parliament, decline in the productivity of the Parliament in ensuring the accountability of the executive, right? So you should write down that how Parliament is. So you should write down about the Parliament. The question is about Parliament. What is Parliament? So you have to write down in first 1 or 2 lines, write down about the role of Parliament. That Parliament is embodiment of the will of the people. It is the highest deliberative, representative, and law-making body in India. It is the pivotal institution in the democracy. 2 or 2 lines about Parliament. Now, one of the Parliament performs multiple functions. Okay? One of the most important functions of the parliament to ensure the accountability of the executive to itself, right? So here you can quote Article 75 Clause 3. Article 75 Clause 3 is the foundational principle of parliamentary democracy. Article 75 Clause 3 states that Council of Ministers headed by Prime Minister shall be collectively responsible to the House of the People, right? House of the People. So it means that government is collectively responsible to Lok Sabha in particular and Parliament in general. Hmm? So, to what extent? So, how Parliament ensures the account? What are the mechanisms to ensure accountability of the executive? So, write down that Parliament has various devices or various mechanism to ensure accountability. What are the mechanism? Question hour, 0 hour, short duration discussion, half an hour discussion, various motions and resolutions. Motions like censure motion, calling attention motion, adjournment motion, no confidence motion, so on and so forth. Then parliamentary committees. There are various parliamentary committees. So these are the mechanisms through which Parliament ensures accountability of the executive. Right? Question hour, 0 hour, motions, calling attention motion, no confidence motion, adjournment motion, censure motion, so on and so forth, short duration discussion, half an hour discussion, so on and so forth. Parliamentary committees, they also ensure accountability of they assist Parliament in ensuring the accountability of the executive. So these are the mechanism. Now, to what extent, okay, Parliament is able to ensure accountability of the executive? बोलना कि to some extent Parliament has been successful in ensuring the accountability of the government. How? Parliament has successfully raised various issues in question hour. It has exposed corruption scandals in question hour. Okay. Then it has kept the executive on its toes by through various motions like calling attention motion, adjournment motion, so on and so forth. Then it has also ensured financial accountability of the government through budget process, by voting and discussion on demands for grants, so on and so forth. So write down some positive aspects, but major part of your question should be critical. It should be related to how Parliament over the period of time has been ineffective in ensuring the accountability of the government. Huh? Despite of some positive role played by the Parliament, the performance of Parliament has been hampered by following factors. Number one, frequent disruptions, pandemoniums, raising of slogans, rushing up to the well of the house, so on and so forth, has has led to the disruption of parliamentary business, particularly question hour. Question hour has been the casualty of the parliamentary disruptions. Question hour gives it gives important opportunity to the members of parliament to ask questions to the ministers. So yes, now these frequent disruptions and frequent pandemoniums had led to decline in the productivity of the parliament. In 1950s, parliament on an average used to sit for 120 to 130 days. Now, in recent times, the number of days of sittings of parliament have reduced to 60 to 70 days, and that has reduced the effectiveness of the parliament. Number one, okay. Then you can write down about the fact that the quality of debates is falling. The quality and standard of debates is falling in the parliament due to various factors like anti-defection law, continuous absenteeism of the member of parliament, biased role of presiding officers, so on and so forth. Okay. Then you can also write down about frequent recourse to ordinance rule. Frequent recourse to ordinance rules have bypassed the parliamentary authority, and it has also reduced the parliament's control over the executive. Then the speaker has started to treat ordinary bills as money bill, and that has bypassed the authority of the Rajya Sabha, because Rajya Sabha has very limited powers when it comes to money bill, right? It has to return the money bill within 14 days. It cannot reject the money bill. It cannot amend the money bill. Okay, right? So by treating ordinary bill, and who has power to decide whether a particular bill is money bill or whether a particular bill is money bill or not? The power belongs to the Speaker of Lok Sabha. and Speaker of Lok Sabha, he comes from he's come from ruling political party. Okay. So then the another factor is criminalization of politics. You can quote the data of Association of Democratic Reforms that the 43% of the current Lok Sabha members, they have one or more criminal cases pending against them. Some of the cases are very heinous, like rape, dacoity, kidnapping, attempt to murder, so on and so forth. Right. So criminalization of politics is also a problem. Then very parliamentary committees, they play a very important role in ensuring the accountability of the executive. But the percentage of bills which are being referred to the parliamentary committees, it is declining. Okay. You can give data. Okay. That in 14th Lok Sabha. Wait. Right. So 60%, 71%. Okay. 2004 to 2009. Okay. 2009 to 2014, 27%. 2014 to 2019, 16th Lok Sabha. 16th Lok Sabha, 15th Lok Sabha, and this is 14th Lok Sabha. Percentage of bills being referred to the parliament is as follows. In 14th Lok Sabha, 60% of bills were referred to the parliamentary committees. In 15th Lok Sabha, 71% bills were referred to the parliamentary committees. But in 16th Lok Sabha, only 27% bills have been referred to the parliamentary committee. So that has also led to, in a parliamentary committees, give important opportunity to the parliament, to the members of parliament, to examine various bills in detail, in depth, in comprehensive manner. But bills are being passed without being referred to the parliamentary committee. And according to 2000 up to 2021, only 12% of the bills have been referred to the parliamentary committees. This has reduced. Then the absenteeism of member of parliament, they do not come to the parliament itself. If the member of parliament do not come to the parliament, do not participate in question hour and discussion, how the parliament is going to ensure the accountability of the executive? Absenteeism is a chronic problem. Then there is lack of lack of advice, lack of assistance available to the member of parliament. Many member of parliament, they are new, they need some legislative assistance. They do not have that legislative assistance. Member of parliament, in this you can also write down that even the important constitutional amendment bills are being passed without any discussion. Forget about referring the bill to the parliamentary committees. They are being passed without discussion. For example, 103rd Constitutional Amendment Act 2009, which sought to give 10% of reservation to economically weaker section of society, it was passed within 4 days. It was constitutional amendment bill, right? So all then another factor is a lack of strong opposition. There is no opposition. In fact, today there is no opposition. In fact, government is very powerful. So lack of strong and steady opposition to provide constructive criticism of government's policies and programs have also hampered the effectiveness of the parliament. Then the majority, absolute majority enjoyed by, comfortable majority enjoyed by the executive in the parliament, has also hampered the effectiveness of the parliament. Why? Because parliament has more than two-third majority in Lok Sabha. It has also comfortable majority with the help of outsiders in Rajya Sabha, so it can pass any bill, it can pass any motion, or it can reject any particular motion or resolution moved by the opposition political party, so on and so forth. Then lack of effective financial accountability. See, to ensure financial accountability, there is budget process. Annual financial statement has to be tabled on the house in the parliament, right? According to Article 112 of the Indian Constitution. Now, what has happened is 76% of the budget of the government has been passed without any discussion. See, during the budget process, there is the second step, which is discussion and the scrutiny of demands for grants of various ministries. Okay, by various department related standing committees. So after the budget is presented, okay, after the budget is presented, the general discussion takes place for 3 to 4 days, and after the general discussion for 3 to 4 days is over, the parliament is adjourned and it goes into recess for 3 to 4 weeks. Now during this 3 to 4 weeks period, the department related standing committees, they scrutinize the demands for grants of various ministries, and they present a separate report on demands for grants of various ministries. Then then after they prepare report and submit the report, parliament again reconvenes. For example, now the parliament has come out of recess and it has reconvened, and now the parliament, in the second phase, the parliament will discuss and vote upon the demands for grants. Now discussion and voting on demands for grants is an important mechanism available to the parliament to ensure financial accountability of the government. The discussion and voting on demands for grants takes place in Lok Sabha. Now, what happens is that the discussion and voting on demands for grants takes place only with respect to 4 to 5 ministries because lack of time. For example, in 2021 budget, only the demands for grants of only 5 ministries was kept open for discussion and voting, and out of these 5 ministries, the discussion and voting took place only with respect to demands for grants of 3 ministries, and the demands for grants of other ministries, it was passed without any discussion by application of what is called as guillotine. It is called as application of guillotine. There is a fixed period of time available to discuss and scrutinize and vote demands for grants. Once that time period is over, on the last day, the undiscussed demands for grants are put together with the discussed demands for grants, and the entire demands for grants are put to vote as a whole. This is called as guillotine. So due to the application of guillotine, in 2021, 76% of budget was passed without any discussion. And this has limited the financial accountability of the government. So these are the certain weaknesses. Now you should not stop here, right? See, you're not supposed to write everything which I am telling you. I'm just giving you various points, various dimensions through which you can write your answer. Then in the last, you can give suggestions. What are the suggestions? So you can write down that there should be fixed number of sittings to be held. Constitution should be amended, and it should fix the number of sittings to be held in every year. Right now, there is no minimum amount of sittings which Parliament has to. There is no minimum number of days for which Parliament is supposed to sit to conduct business. So you can say that the Constitution of India should be amended, and there should be fixed number of days should be specified for which Parliament must be functioning. Then there should be a special session apart from 3 sessions to make up for the time which was wasted, which is wasted due to pandemoniums and adjournments. Special session can be the second. Then you can give that it should be made compulsory to transfer important bills to parliamentary committees, except in certain exceptional circumstances. Most of the bills should be compulsorily sent to or referred to the parliamentary committees. It's not all, but in certain exceptional circumstances, you can pass the bill without referring. But apart from that, every bill should be referred to the parliamentary committees, right? Then anti-defection law, it should be the power to decide cases of defection under anti-defection law should be taken away from the presiding officers and should be given to the independent tribunal, which we should have judicial members. Okay. Then those members who continuously remain absent without any reason for more than say 15 days or 1 month, they should be given some disincentives. They should be given some punishment, financial disincentives, or any other disincentives, right? There should be some accountability mechanism. Then budget should be discussed more. It should be made compulsory to discuss the demands for grants of at least half of the total ministries and departments. It should be compulsory, because it is very important. Then the parliamentary committee proceedings can be live streamed. This can also be one of the recommendations, so that people know what is happening in the parliamentary committees. Okay, there are other counter arguments as well, but you have to give suggestions. You can give this. Then you can also write down about how it is very important to give enough time to member of parliament to discuss the bills before those bills are put to vote. Give enough time to member of parliament. Give them advance copies of the bill 1 month or 2 months before, so that they can study the provisions of the bill and they can participate in the debate and discussion meaningfully. They can have informed opinions, right? This can be. Then you can also talk about that, we need to increase the legislative assistance to member of parliament, the fellowships like lamp, legislative assistance to member of parliament, they should be increased. Currently there are 25 such fellowships, wherein these fellows are attached with individual one of the 25 member of parliament. They will help the member of parliament in drafting questions, answers, and various key provisions of the bill. The lamp fellowship is very prestigious fellowship, by the way, right? So legislative assistance should be increased to the member of parliament, particularly those who are new, so that their capacity to understand the legislative business and to ensure the accountability of the executive increases. So you can give so many suggestions, right? And this is how you can end your answer. So this is it. I will stop here. So to summarize what I discussed, see, UPSC is about your personality. UPSC is the test of your personality. At every stage of the examination, UPSC will test your personality. In prelims, UPSC will test your time management skills, which is an important part of your personality. It will test your ability to handle pressure. It will test your judgment. 50% questions, 50% answers, 50% answer, you have eliminated 2 questions. So how you use your judgment, how you use your common sense, so in mains, UPSC will test your analytical ability, your critical thinking, your positive attitude, whether you're a positive person or not. You can't go on criticizing everything, right? And you can't go on defending everything as well, right? Then so it is not as if UPSC is only test your personality only in interview stage. No, at every stage UPSC is going to test your personality. This is a very important thing. Second thing I've told you is that you should focus on answer writing. Answer writing is very, very important. And for answer writing, consolidation of what you know is very, very important. All these things should come on your fingertips. Now they will come only when you will have hold over your content. Hold your content will only come when you will revise again and again, and this will come only when you will limit your sources. So everything is interlinked with each other. All right, right? So thank you so much for listening to me patiently. So the very important thing which you should remember is everything is secondary in front of the fact that you should enjoy this process. The beautiful UPSC is a beautiful examination. Do not get overawed by this examination. Do not underestimate this examination as will. Maintain balance and enjoy the process. And please follow long-term strategy. Do not follow short-term strategy, right? Be confident, be determined, be enthusiastic, show that enthusiasm to learn and understand, focus on conceptual clarity, and there is no power in this world who can stop you from clearing this exam. And we are there to help you in achieving your goal. All right. So thank you so much. With this, I end this lecture. So see you in our classroom program. We will be starting with Indian polity, right? The first lecture itself will be on Indian polity. So see you there in our classroom program. Thank you and all the best.